homicide, death at the hands of another.
Vinny, it's very significant because now we know it wasn't an accident. It wasn't blunt force trauma. She didn't fall. And, I know Laundrie's family attorney has said that he's not a suspect, but he doesn't speak for prosecutors. And frankly, even law enforcement, they don't make that decision. Prosecutors do. For all we know, Brian Laundrie could be under indictment right now for murder. That indictment is sealed until he's arrested. So folks that are saying that he's not a suspect or he's not a target of the investigation, there's plenty of circumstantial evidence here, including this history of violence, which viewers are watching right now.
Oh, well, we've got more circumstances to get to. They leave together, and he is in an agitated state, and she is crying. This is huge.
Huge. We love this evidence as prosecutors, the prior bad acts, the history of violence, to bring all this evidence and to show that absolutely there's a violent history between these two, and it just adds on top, layer by layer, manual strangulation, history of violence, and there's plenty more evidence here.
Brian Laundrie goes missing. In other words, Brian Laundrie goes away, hides, flees. This can be used against him.
Absolutely. Flight is always consciousness of guilt, and more evidence that we love as a prosecutor. And we skipped one piece of evidence which isn't admissible, but law enforcement can use. Two go, one returns, and then what does Brian Laundrie do? And the family, they don't call law enforcement, they call their lawyer in New York. Not admissible in court, but certainly consistent with guilt and a murder.
We know, and what's become public, that you could prove a circumstantial case to a jury beyond any and all reasonable doubt against Brian Laundrie.
Vinny, I'm not only confident, I'm very confident I can get a guilty verdict against Brian Laundrie based on the information we know now. And we know law enforcement has more because they've executed search warrants, and I can guarantee you the grand jury subpoenas have also been issued. But let's talk about this case and how eerily it is similar to a recent case, 40-year-old cold case murder, really bad admissions from an older white male criminal defendant. The defense in their opening statement saying that this is Asperger's. This is someone who acts and says strange things, eerily similar to Bob Durst. But what they have in this case that they didn't have with Durst is Norris Black, who lived across the street. So they have another suspect. But gotta agree with Kirk on this one. It's a much tougher case than I think the prosecution is making it out to be. These cold cases always are.
Crime and because of this condition that he has involving Asperger's, somehow put himself in the middle of something that he has nothing to do with? Is that even possible?
I mean, it certainly is possible that someone can develop an obsession with something, whether you have autism or Asperger's or anything on the spectrum. Obviously, the prosecution here, they have more evidence than that. He did allegedly rake the footprints and destroy evidence. He knew information that, frankly, wasn't public and no one else had. So I understand why this is being prosecuted. Really, all the signs point to one individual, despite what the defense says. So it's more than his obsession with Janelle and this particular case. The state has a lot more evidence than that here.
Are they on the offense in disproving a citizen's arrest? How do you approach that issue as a prosecutor? Do you wait for your rebuttal case? Do you do it out of the box?
You got to take it head on. And Vinny, you and I have talked about this case and Kyle Rittenhouse's two murder self-defense cases that from the jump we knew were going to trial. And, I've been on Ashley's show with the McMichael's attorneys. I mean, they believe in this defense and they say Glynn County is the perfect place for it. Let's not forget that Roddy Bryan leaked this video, sent it to a local radio station because he thought it would actually exonerate him. So, this argument is something that the prosecutors have to address head on. They have to address Georgia's citizens arrest statute, which is unique in the country. Obviously, there was no hate crime statute at the time. That's coming in federally. But no question, when you voir dire those 600 jurors plus the 400 that are going to come after, it's just like George Floyd and Derek Chauvin. Everyone has seen all the evidence in this case. So voir dire jury selection will be critical because you have to determine as a prosecutor what these prospective jurors think about those two very important issues, the citizens arrest law plus the self-defense argument and the use of deadly force.
Attorney generals put like a moratorium on death penalties, yet they're in front of the Supreme Court trying to put someone on death row who was taken off of death row by another court. What's going on here? I'm confused.
Well, first I got to say Justice Kagan is brilliant. She was my law school professor more than 20 years ago.
Of course she was.
Yeah.
And you got an A. I know. You got an A, Neama. We know.
But look, when you're the Justice Department, especially on these cases that are going to be litigated for years, you got to defend the guilty verdict. You can't let the circuit courts get into the trial court's discretion, questioning what evidence comes in or out. So I understand what the Department of Justice is doing, even though Attorney General Garland has put a moratorium on federal executions. And even Justice Barrett, she's like, what's the government's end game here? But we really got to protect those verdicts at the trial level. That's what this is all about.